Welcome to the SecureWorld Sessions. We're a new cybersecurity podcast that is all about access. Access to people and ideas that can impact your personal cybersecurity career and help you secure your organization. Hi, my name is Bruce Sussman. I'm Director of Content at SecureWorld and also your podcast host. And in today's session, we're opening the file on the shifting cybersecurity and privacy landscape.
Especially if you look at the C-suite, the leadership level, those executives are almost afraid to delve into this. It feels, again, like Pandora's box. I'm going to open up this can of worms that I don't know if I'm going to want to deal with. But a lot of times you might be doing good things. You just don't know it.
That is cyber attorney Jordan Fischer. She is also managing partner and co-founder of Xpan Law Group. And Fischer's sessions at our regional cybersecurity conferences are almost always standing room only. And I think the reasons for this are twofold. One is she is super smart. But second of all, she explains things in plain English instead of legalese. So she is our featured interview today. We're going to talk about the challenges in the shifting landscape, how to approach this to make positive traction in your organization, and the types of exposure not complying is leading to now for organizations, and more. Also, in today's episode, we're talking 2020 cyber threat landscape predictions. We're going to hear what Trend Micro's research team is thinking. And the great news is if you're listening to this podcast in, say, 2025, well, you can go back and fact check the predictions. This is based on the new paper titled, "The Future is Complex, Exposed, Misconfigured, and Defensible." Love that title. Trend Micro is our exclusive podcast partner. Now, on to our featured interview with attorney Jordan Fischer of Xpan Law Group. And to frame today's topic, think of those trips you made to an arcade when you were a kid. And specifically, the game Whack-A-Mole. Yeah, that annoying sound, right? The security and privacy landscape in the United States is now like that game because new regulations keep popping up state by state. Which state regulation will pop up next? As I interviewed Jordan Fischer during a networking break at SecureWorld New York, it became clear how this creates confusion. Listen to how Fischer frames it as we start our interview.
So each state is really starting to weigh in and approach privacy and security in different ways. Now, we have the traditional approach, which is data breach regulations, right? So I have a breach, and each state has their own requirements as it relates to what information is going to be deemed sensitive that would require you to notify, what that notification needs to look like, the timelines. Some states, it's very open-ended, right? Reasonableness. Other states, California being one of them, dictates the size font you can use in your notifications. So we see a lot of broad spectrums on that. We've seen some evolutions in what those look like. So that's been an area of sort of constant change. A lot of those changes are either related to what is going to be considered personally identifiable information that dings you for a breach, or the timelines that you have to respond to a breach, right? So instead of being within a reasonable time period, it's 60 days, 30 days, 72 hours, things like that. We also see changes on the privacy side, which is, I think, where you're seeing a lot more evolution and newness in the regulatory space. And what I mean by that is we're starting to see regulations pop up across the United States that are either oriented to specific types of data. So biometric data is a great example of that. We have the Illinois biometric data law. It's been on the books for a couple of years. We're starting to see other states, Texas, Florida, et cetera, push out biometric data-specific regulations. And then we see these broader data protection regulations that are more analogous to what we're seeing internationally with the European Union's General Data Protection Regulation, where they are going to be regulating data generally, if it's considered personal data, and there's going to be a lot of affirmative obligations. So a good example of this is the California Consumer Privacy Act. We have Nevada's Privacy Act. There's pending ones in Texas. You have things going on in New York, Massachusetts that are all sort of versions of that more broader privacy regulation. So really that's what you're looking at from a very broad brushstroke of what's going on in the U.S. domestic regulatory space.
Okay, and first of all, you should know my head is spinning right now, and I can just imagine if I was an organization concerned about meeting these privacy and security regulatory requirements that are passed all over the place. Where do we start? What do you advise your clients? Like, where do you look for where you really need to make sure you're in compliance and things of lower priority? Because I hear from organizations we can't do everything at once.
And you really hit upon the biggest challenge, which is I have a moving target, and B, multiple different targets. And that's a challenge for any company to hit. One of the things we always advise companies is that knowledge is power. So the first step is, what are you doing currently? Right? If you don't know where your data is stored, if you don't know what data you're collecting, if you don't know what your security is, you're behind the 8 ball in every single regulatory environment, right? You're never going to be able to even make the analysis of what should I do next if you don't know where you stand right now. Now, if you do know where you stand right now, it really is helpful to start to develop a cross-mapping system where you can say, okay, we're going to go towards this framework. It could be a regulatory framework like GDPR, it could be CCPA, it could be a standards framework, so like NIST or ISO, and you're going to have to pick something that you're moving towards because you need goals, you need metrics, you need to have a plan in place. And the key is going to be having the right people, either internally or externally, start to cross-map that to the other things that you're required to comply with, and to be able to maintain that, because this is a living and breathing thing. And if you talk to me next week, there's going to be a new state I talk about that has something going on. And unfortunately, that's the world we live in right now. But almost every regulation, almost every state, the legal aspect is about reasonableness, right? So did you take the time to make an informed decision and then make a reasonable decision based off of that? If you didn't even know that you had to comply with the CCPA, that's not a good position to be in. If you know you have to comply, you know you're doing X and you're moving towards Y, that's a good position to be in, right? Because it is evolving, and I don't think anyone's looking for a static, this is what you need to do, this is the encryption level you need to have, but why are you using this encryption level, and what are you basing it off of? Having responses to that, that's going to be key under most of these regulations.
Okay, yeah, that makes sense. I see exactly what you're saying. Now, one of my questions that I have for you is, let's say you have an organization where maybe you're getting resistance from leadership, for example, to implement something that would push you down this road. Maybe it's expensive or time consuming, you need more people. What are the real world consequences for organizations that don't, comply with these regulations, or try and, hide from some of the lesser ones, let's say, for example?
Just like the regulations, that world, that liability world is also evolving. So from our perspective, I see a couple of different ways that you could be impacted in a negative way, i.e. dinged financially or in some way, subject to liability for this. So the first is the easy, which is the regulations themselves might expressly say you can be fined for X, right? So that's the GDPR approach. You can be fined 4% of your global revenue or 20 million euros, whichever is higher, right? That's the one that made all the headlines. So you can be subject to regulatory fines. You have seen the FTC in the domestic side issue regulatory fines for failing to follow the FTC guidance, or for failing to be transparent about their practices. So you have regulatory fines. This is a pretty common thing. The other exposures that you could be subject to are more and more regulations are creating a private right of action for consumers or data subjects to bring lawsuits against a company for failing to abide by the regulation. We see this more and more on the European side because the GDPR does have this express right of action, but the CCPA has a version of that, right, that's been negotiated and sort of tweaked and changed, but it's there. And sometimes there's no cap on damages. Like the GDPR does not necessarily have an express cap of, say, $7,000 per violation, whereas the CCPA does have that cap, but there's still that exposure there. And facing 28 lawsuits in 28 different member states can be quite costly just from an administrative side, but also from a liability side. And then the third way we're seeing exposure is if you are a processor who is signing agreements with your clients, your customers, your own vendors that are saying you are doing X, right? I'm complying with the GDPR. And then if you are failing to do that, that is a breach of contract action. And that's a pretty standard lawsuit that we see in the legal space. And so there's another potential exposure that you could have. And the concern, frankly, with the breach of contract is if you're agreeing to do X on behalf of, say, a processor, and then that processor is signing an agreement with a controller saying, we're going to make sure that all of our vendors, there's multiple levels of liability in there, and how you establish that is going to really dictate what your true exposure is. Because I might understand that I'm providing X service to my client, but I might not understand the true exposure because my client is then providing X service to their client. And I might be liable for what I do that pushes up that chain and causes non-compliance. So there's a couple of different avenues that you could be liable, and it's really important to understand your risks in each avenue when you're going to sort of look at your full exposure under these regulations.
Yeah, and as you explained that, it kind of reminded me of something I think I saw you say during your presentation, was that increasingly consumers, for example, who might be filing a suit after a cyber incident, don't always have to prove actual damages now. Wasn't there a time where that was more likely the standard, but now it's like potential damages or something like that?
Well, it's again, like I think the word of the day is evolving, right?
Okay.
So I think this is an area that's evolving, especially, so let's focus mainly on the United States, because that's where we're sitting right now. Historically, it's been very hard for individuals to show standing in order to bring a lawsuit in court. Now, you need to show standing. That's a very traditional judicial doctrine. And as part of standing, you have to show that you were damaged, right? You were actually damaged. So the potential future harm historically has not been enough to show actual damages sufficient for standing. And so the issue in the breach context was my data was stolen. I have had nothing happen, but is the fact of my data being stolen, is that damage enough without having my identity stolen and my credit cards amassed a huge debt and all this stuff, right? Things that we can actually attribute value to versus like my data is now out there in the internet, and what is the damage to that? So that's been hard. But by creating these statutory right of actions, they're able to get around that because we don't need to show damage, we just need to show a violation of the regulation, and that alone is going to give us standing in order to get in front of a court. But that's evolving, right? We're seeing the common law evolve to try to catch up where the statutes aren't filling in that gap. And this concept of like a duty of general care or information fiduciaries is starting to evolve, where if you collect information, you're going to have a duty to that information beyond just, I have to show I was damaged by it. But that is an area that is, frankly, a big one to watch in the legal sphere, because we're seeing different courts take it differently and approach it differently, and we don't necessarily have sort of a standard method across the United States of how to handle that specific issue.
Yeah, that is crazy. I mean, honestly, I don't know how you keep track of it, Jordan, so that's pretty impressive.
I don't sleep much.
I was going to say. Is the answer to these challenges a national cybersecurity or privacy law in the United States? And what are the key things Fischer would advise every organization and leader to do to approach this topic? We'll talk about those things when our featured interview continues. Now to some 2020 threat landscape predictions from the highly regarded research team at Trend Micro. The team just issued their 2020 predictions report, and here are 3 of their top prognostications. Number 1, attackers will capitalize on wormable flaws and also deserialization bugs. Researchers put it like this: that more exploitation attempts on critical and high-severity vulnerabilities like the wormable Blue Keep will be disclosed in the new year. Also, flaws and weaknesses involving the deserialization of untrusted data are going to be a major concern, even in enterprise application security. Rather than finding and chaining several vulnerabilities together to execute malicious code, attackers will increasingly exploit deserialization bugs to more easily gain control of systems, even in complex environments. So that's really interesting. Number 2, critical infrastructures are going to be plagued by more attacks and production downtime. The researchers predict that in addition to ransomware, which remains an attack of choice, there's going to be a rise in botnets. Botnets that mount distributed denial of service or DDoS attacks against operational technology networks. Also, researchers expect more attacks on manufacturing systems that use cloud services. And watch for supply chain attacks where third-party vendors are compromised as springboards for threat actors to get to critical sectors. Number 3, attackers will outpace incomplete and hurried patches. What does this mean? Well, sysadmins will find themselves in a dual predicament, ensuring the timeliness as well as the quality of patches being deployed. Because incomplete or defective patches can not only break and disrupt critical systems, there have already been cases of incomplete patches being bypassed to exploit the vulnerability the patch is trying to fix in the first place. However, delaying patch application can also expose systems to threats, so patches will increasingly need to be complete and timely. Now that's today's Trend Micro Top 3. I've only scratched the surface, so I'm going to place a link to the 2020 predictions and white paper in today's show notes. It is both a fascinating and informative read. Now let's get back to SecureWorld New York and our interview with cyber attorney Jordan Fischer of Xpan Law Group, which, by the way, is a law group owned by women. Now, I've heard a number of cyber attorneys and many of the leaders we serve at SecureWorld conferences across the continent say that a national cybersecurity or privacy law would certainly make life better for organizations doing business in the United States. So I asked Fischer about this, and she said, wait a minute, before we go wishing for something like that, we might want to think through what that could mean. Listen to this.
So I don't think it would be better in the sense that I think it's hard to sit here and say it would be better for society to have a national privacy regulation. I think it would be easier. I think it'd be easier on companies. I think it'd be easier on individuals because if you have one standard, understanding what that standard is, both from a company operational side and from a consumer side, frankly, would be easier, right? So I don't have to understand, okay, if I'm in Illinois, I have biometric data protections, but if I'm in Pennsylvania, I don't, right? So it'd be easier to understand. The problem is, what is that law going to look like? Because right now, a lot of the states have heightened protections than we're seeing nationally. And we don't necessarily, from a societal standpoint, do we want to give up some of those protections in order to have that cohesive national view? And do we feel like that national view is going to be sufficient to protect us? So it's kind of hard to say, sitting here, that it would be better. I do think that it would be more efficient, and I think that companies could more easily hit a national standard than they can the state standard. And my concern is that companies will say, this is too hard. It's like opening Pandora's box. So not only am I not going to comply with anything, I'm just going to walk away from it. I'm going to do what I want until I actually get called out on it. And I don't think that's a good response. So if the national standard is going to get all companies closer to a higher level, then I think you could argue that it's better. But my concern would be that these stronger protections we're seeing in certain states would be dampened by a national data protection regulation. But it's so hard to tell right now because we don't know what that would look like.
Yeah, that is a great question. I see one size fits all versus, something that's more detailed and case by case or state by state for that environment there. Yeah, it's a tough argument. So, and
I will say, I think most of my clients would prefer one national, right? Because the benefit of the GDPR we see is that everybody is trying to hit this one metric, right? Each state has a little bit of discrepancy to sort of change things, but for the most part, the floor is set by the GDPR. And we have seen efficiencies. We've seen more companies driving towards that. We're able to see member states sort of work together to make sure that companies are complying. So there are a ton of benefits. So I don't want to say that there's not a ton of benefits, but I think we need to be thoughtful of what we might be giving up at the state side in order to obtain those benefits and whether those benefits are going to outweigh what we have right now at the states.
Yeah, that is always a great question. So that's excellent. And speaking of questions, the last one I have for you, do you have any parting advice in this area? Because I think for organizations right now, at least from the leaders I've talked to, they're struggling to keep up.
My one piece of advice is don't be afraid to ask questions. I think that a lot of, especially if you look at the C-suite, the leadership level, those executives are almost afraid to delve into this. It feels, again, like Pandora's box. I'm going to open up this can of worms that I don't know if I'm going to want to deal with. But a lot of times you might be doing good things. You just don't know it because you don't have the documentation in place, because you haven't thought, okay, so we're putting stuff in the cloud. Is that a good thing? Is that a bad thing? Are we making informed decisions? And so I would say the first thing, if you've never delved into this world, start asking questions. Where do we store our data? What data do we have? What are we doing with that data when we have it? These are simple questions that actually will probably provoke responses that will start the conversation going. And that's the first step with anything. If I come in and just start asking all the legal questions that I would ask, your team's head's gonna spin, right? You need to have some thought process behind this. And then it's not scary, it's not daunting. There are ways to do this that are organically built within your organizational structure that also comply. So you're not looking at, we can no longer collect data from X. We can do that, but we have to do that thoughtfully.
Is your organization finding a thoughtful approach to tackling the shifting cybersecurity or privacy legal landscape? If so, will you let us know so we can share what's working? Our address is media@secureworldexpo.com. That's media@secureworldexpo.com. Well, speaking of sharing comments, on our previous episode, we interviewed Huawei's chief security officer about whether the company can really be trusted to build the world's 5G networks. And Mike W. had this to say after listening to the interview. Great episode, and I just wonder how other vendors would look if they were subjected to the same level of scrutiny. There have been some pretty big names who have had some pretty big security items identified in their products. Excellent point, Mike, and thanks for the comment. Now let's talk about next time. We are starting a 2-part mini-series on career development. We're going to learn about some aha moments from leading women in cybersecurity, hear a cyber headhunter discuss the value of certifications, that's going to lead to a big debate, and also a CISO who says every security leader needs to develop a stop list, and that can actually boost your career. We're going to cover those things in our next 2 episodes. Also, if you have a minute, would you please rate or like our podcast on the platform where you listen? That will help spread the word and carry out SecureWorld's mission of connecting, informing, and developing leaders in cybersecurity. On behalf of the SecureWorld team, I'm Bruce Sussman, your host of the SecureWorld Sessions, and let's catch up again on the next episode.